I'll call the second case now, Smart Growth Minneapolis versus the City of Minneapolis. And counsel, in the first case, you can feel free to exit the WebEx with the court's thanks.
Thank you.
Justice Hudson, you should mute your microphone.
Thank you.
All right, let's see. It looks like we've got both counsel. Let's have you test your microphones first. Just identify yourself for the record. If you could, please, let's start with counsel for the appellant.
Jack Perry.
Thank you, counsel, and counsel for the respondent.
Good morning, Yvonne Ludmer.
Good morning. All right, thank you, counsel. So we'll begin then with the argument. We'll give each counsel 3 minutes of uninterrupted time, and then I will ask members of the court to see if they have questions at that point. So, Mr. Perry, you have the floor. You may proceed.
Thank you, Your Honor. May it please the court, Jack Perry from the Taft Law Firm here on behalf of the appellant petitioners. City's 2040 plan has been described as the furthest reaching residential upzoning or densification enactment of any U.S. municipality. The plan provides for nearly 150,000 new residential units. And for context, the UQB requires mandatory environmental review for a residential development of just 375 unattached units, or nearly 400 times fewer units. The plan is environmentally significant because the state's environmental policy, quote, recognizes the profound influence of high-density urbanization, end of quote. And petitioner's environmental expert has opined the plan is, quote, likely to materially adversely affect the environment, end of quote. Petitioner's resulting mirror action has nevertheless been twice defeated by city's two defenses thereto. The city's first defense, which is the alleged preemption of MIRA, is defeated by Section 116b12 and the Peer decision. Section 116b12 plainly provides that, quote, the rights and remedies provided herein shall be in addition to any administrative, regulatory, statutory, or common law rights and remedies now or hereafter available, end of quote. And to preempt MIRA, Peer thus equally plainly requires, quote, express statutory language, end of quote, which, as discussed by the special concurrence below, does not exist here. City's second defense, which is the alleged speculative nature of the environmental harm, is defeated by Venota Golf and the plan itself. Per Venota Golf, city's plan, not its city code, controls its land use for at least the next decade. And because it expressly wanted to expedite residential densification, city's plan had to and did provide for residential upzoning or densification as a matter of right, without any subsequent discretionary review thereof. For example, in the interior 1 and 2 zoning districts, which cover the former single-family residential zone, quote, individual lots are permitted to have up to 3 dwelling units, end of quote. And other than height restrictions, the same is true in each of the other new zoning districts. Per this court's decision in 1984 in Chanhassen Estates Residents Association, quote, approval of a permitted use follows as a matter of right, end of quote. There is nothing speculative about the plan's massive residential build-out. It's being approved therein as a matter of right. Thus, both of the two defenses fail, compelling a reversal and a remand. Thank you.
Thank you, counsel. Let me start with questions. Justice Moore, do you have any questions?
I do, Chief. Thank you. Mr. Perry, perhaps it'd be helpful to start it about what this case is about and what it's not about. Is a proper question for us here at this stage whether your client's alleged sufficient facts to survive the Rule 1202 motion, or whether you actually established the prima facie showing under MIRA?
The way I read the defense of this, Justice Moore, is that they're raising two legal defenses. They have, to be fair, questioned whether we have made a prima facie showing, but they have no evidence to support that. We have an expert opinion, we have a verified complaint, We have our contention is consistent with the state's environmental policy. It's consistent with the EQB's required mandatory review for several hundred times less units. And in response to that, what the city put into the record below as to our prima facie showing is a Rule 5604 affidavit. And as this court knows, the Rule 5604 affidavit is simply saying we don't have the ability at this time to address those legal issues. On top of that, we submitted in our reply brief and in the opening complaint both the comments of the two highest city officials, the Council President Bender and the Mayor Fry. Both of them made it absolutely clear that there was no environmental review done. Bender publicly stated that she didn't want to do that because she wasn't sure she could get over a lawsuit such as this. Fry misstated to the public that, hey, there had been an environmental analysis, but
Counsel,
the record shows that there was no expert.
Counsel, if I could just interject there, not to interrupt unnecessarily, but again, getting to the procedural question here, it seems to me that you're diving into the merits of the respective claims here. I mean, isn't the procedural posture of this case an appeal from a ruling of the court dismissing your client's claim for failing to state a claim upon which relief could legally be granted?
That is absolutely right, Justice
And
Moore. Sorry to take you in a different direction.
Is there another case that this court has considered under MERA that's come to the court at that stage of the litigation?
I am not aware of that, Your Honor, and I have in a binder in front of me every single MERA case. I think there's 30 of them since 1973, and I'm not aware of a single one. Every one, the record has been developed.
I mean, generally, and I think you're correct on that. I think the record shows that the cases that have come to this court have come after Rule 56 motions or after some sort of an evidentiary proceeding where the parties have presented evidence and a district court has decided whether the prima facie showing has been met and whether the respondent has rebutted it or provided a affirmative defense under the statute. Is that your reading of the law as well?
Yeah, I am not aware. I think the most recent White Bear Lake case is more akin to what the procedural posture that this court has been confronted with.
So if the court remanded and agreed with your position, what additional evidence would you be prepared to bring forward to the district court to try to prove the causation element and address the other issues that the city is raising regarding your prima facie case?
I think the next steps, Justice Moore, are laid out in opposing counsel Ludmore's affidavit, pages 3 through 5, paragraph 7A through 7F, I believe it was, where he lays out what the city would do in response. Because I think at this point we have made our prima facie showing, and under 116B04, small b, close paren, the burden now shifts to the city to either rebut that or satisfy the affirmative defense that there is no alternative, et cetera, et cetera. And that's consistent, I believe, with Ludmer's affidavit, and that would be the next step in front of the trial court.
If I could just ask a follow-up question, Chief. Mr. Perry, once the city adopts its comprehensive plan, what immediate effects does that have? I mean, are there further actions that are going to be required before that comprehensive plan is actually implemented with regard to zoning, for example?
My understanding is that the subsequent steps to implement the plan have been taken, but I would have to defer to the precise procedure to Mr. Ludmer. But the way the plan works following the 2006 decision of this court in Rebuttal Golf is any subsequent zoning ordinance has to conform with the plan, because it is, in the words of this court, it is the primary land use control. It has supremacy over the zoning code. Everything has to comport with the plan, which is why we think this is so important, because this plan creates, as a matter of right, permitted use 150,000 new residential units.
So I suspect the city may say, well, why don't we wait then until the zoning ordinance are actually modified or there's actually a project presented for permitting to the Minneapolis city authorities? Why shouldn't smart growth wait and then challenge that particular adoption of a zoning amendment, for example?
The reason is that the proposal in the plan is to approve as a matter of right and as a permitted use residential units throughout the city, 150,000 of them. That is what we are objecting to. If we do as the city, you are correct, the city has said, well, let's just wait, we'll do this down the road. But there will never be a project for 150,000 new residential units. Instead, they will be one-offers, and in fact, since I represent a lot of developers and other folks, you would typically try to stay just below the 375 unit threshold to avoid environmental review under MEPA. And that's the entire reason why we're moving forward here, is that we are objecting to the plan because it is what approves, as a matter of right, these residential units. There will never, ever be another time. And if there is a subsequent environmental review of a project, it will be of that project. If it's 100 units, 200 units, whatever it is, it will never be of the entire impact of this, which is 150,000 residential units.
Thank you, Chief. That's all I have.
Justice Thiessen, do you have any questions?
I don't, Chief.
Justice McKeag?
I do not. Thank you, Chief.
Justice Chudich?
I guess to just follow on about why a lawsuit is needed now, when there's really no guarantee that this plan will materialize. I understand your argument that there's no further permission needed to build a triplex where there was a single family home before. But, it depends on whether there are development projects or if the plan's significantly amended. Does that affect our review at all?
I think the short answer is no. Your question has a surface appeal, and believe me, we have discussed that amongst the appellants group before bringing the lawsuit, is can we wait? The problem is that, again, as I mentioned to Justice Moore, is there will never ever be before any court the opportunity to challenge the entire plan itself. And the entire plan itself, what we are specifically challenging is that they have now, by the plan, approved 150,000 residential units. And the White Bear Lake case and Justice Anderson's dissent, I think, gives a perfect example of why you do this now rather than later. The dissent by the Chief Justice and Justice Anderson specifically talked about, and I thought raised all sorts of legitimate issues about after the fact trying to apply mirror when the damage has already been done, and in that case for 40 or 50 years. Here we are doing, Justice, what the author of MIRA from Michigan said needs to be done, is to bring the lawsuit before there's environmental harm so as to prevent it. And that's how MIRA is set up. It provides under 116B07 for injunctive relief for that very reason. So we are trying to get ahead of it to avoid the myriad of issues that the dissent raised in the White Bear Lake case. Understandably so, because it's what do you do after the fact? That's not how MIRA is supposed to work.
Nothing further. Thank you.
Justice Hudson?
Counsel, you may have already answered this, but the Court of Appeals relied heavily. Well, the Court of Appeals noted that both sides relied on the Stansel decision, but the Court of Appeals came down on the side of saying we read Stansel to say we cannot. MIRA was not designed to address speculative concerns. What's your argument for with respect to Stansel and how the Court of Appeals handled that?
Yeah, and it somewhat dovetails, Justice Hudson, with just my answer to Justice Moore's earlier questions, is that Stanzel it's the only other case that deals with a proposal that is exempt under 4410, 4600 subpart 2026 for governmental action. And the court had no concern with that. They allowed the mirror claim to go forward, despite the fact that it is exempt under MEPA. But they, as you said, addressed the issue, the Court of Appeals addressed the issue of was a prima facie case proven in that case, and was it too speculative? And my response to you is the facts in the Stanzel case are so extremely easy to dismiss with. It said that there is going to be an economic impact because of a target located 2 miles away from the Historic Preservation District, and there's going to be an impact. If I came before you and argued that, I would be embarrassed. That is not a colorable claim, I don't believe. All due all due respect to the lawyers bringing that case, that was speculative. Makes no sense. How will the economic impact of target affect the historic preservation? They had no expert. They didn't have anything to support that. Here, in contrast, we have a plan that approves as a matter of right, no subsequent discretionary requirements, 150,000 residential units. Nothing can stop that. The city expects 48,908, according to Appendix B, I think it's figure 1 or 4. They expect that. So this is not a what if. It is going to happen, and maybe it's a good thing, Justice Hudson. We're not getting into the merits of it's a good idea. We're just getting into the merits of if it's expected by the city, that's their word, expected. And if it's approved, which it is, in fact, it's called a permitted use on page 67 of the plan, is there an environmental impact, which is Justice Moore's question. Have we satisfied our prima facie showing? And there's no question we have satisfied that. Now, ultimately, will we be successful? Justice Moore is correct. We don't know. We have several steps to go, but MIRA requires us to make a prima facie showing as to a whatever conduct it is. This is clearly conduct, and in fact, I cited in the reply group to 4 different cases where this court, I think 1976, 1979, 1981, and then 1992, has applied MIRA to local decision-making, local zoning decisions. The only difference here is the local zoning decision is by plan, which has been, allowed and required by Mendota Golf. So that's the only difference between those cases and this. But there is no doubt that they have with the plan approved of this use, and that's not speculative because the city says it's expected, and they haven't pushed back in any meaningful way on our prima facie showing.
Lastly, counsel, I think you've touched on this. I presume you will say that there's really no room or no reason for the court to look into the underlying reasons for what the city is proposing. Because clearly, not clearly, but it seems they're attempting to get at the continued lack of affordable housing and the continued segregation and all that comes with segregation, the ills that come with segregation in the city of Minneapolis, but that's not our concern, I presume.
Well, yes and no. We put a footnote in our opening brief, and it's not a coincidence that our co-counsel, my co-counsel is Nikema Levy-Pounds, Armstrong now, and she and I are working on an education case that was up in the Supreme Court a couple years ago too. That is a major driving force for our group. Our group believes that there are things that can be done for affordable housing. We substantively do not believe that turning over to developers is a good idea, that there are ways to do that. And our hope is, and our footnote was pretty clear, our hope is that during the MIRA process, we'll be able to address some of those substantive issues and some of those unbelievably substantive deficiencies that we have identified. We are, and I guess one other point on that, Justice Hudson, because we believe in this deeply, is that we push, and the reason we have Mayor Fry's comment in the record, Exhibit 9, is because we asked these questions. We were trying to get them to do this so that we wouldn't delay the process. They didn't want to spend a couple $100,000 on a lawsuit. They wanted this to be done the right way. And under the Bryson 2 case in 1976, this court said the city has to show leadership. It has a greater duty to comply with MIRA than individuals. We asked them to do it, and they stiff-armed us, both the council president and the mayor, despite the efforts by our constituents, the petitioners' members. They stiff-arm us. So yeah, the substance matters. I just want to make sure that you're clear. We're on the right side of the substance on this thing.
I have no further questions, Chief.
Justice Anderson, do you have questions?
I have no questions.
All right. Go ahead, counsel. You have about little over 10 minutes left in your principal argument time.
I didn't expect to have any of my own free time. So I guess I want to go through very high level my responses to both defenses. The first defense, as it relates to the Court of Appeals ruling that an EQB exemption rule trumps MIRA, is defeated in 4 different ways. And without belaboring it, it's defeated by the shall be in addition to language from MIRA itself. It's defeated by peer. And the important thing I want to say about peer is not only did they provide this directive that you can only preempt MIRA if there's express statutory language or express legislative directive, is in that case, the context is critical. They had already done a mandatory EIS. They'd already done a mandatory ALJ review, and yet they said it wasn't trumped. And if, as this court has repeatedly said, MIRA is about the paramount concern for the environment, it would have made more sense to preempt MIRA when you've already had exhaustive MIPA review, rather than in this case where there's been no MIPA environmental review. The third argument on that is that both in the Great Northern case, the Kmart case by Justice Hanson, I think wrote it, then the In re Hubbard case, which I think the chief was the author of that. All 3 of those cases say EQB had no authority to enact anything under MIPA that trumps MIRA. And in fact, EQB acknowledges that. If you look at the Minnesota Rule 0300 subpart 1, they say their rules are limited to MIPA. And their authority under MIPA, under 04 subdivision 5A, was related to MIPA. It had nothing to do, they had no authorization to get into MIRA. And the final point on their first defense is that consistent with what the Peer case said in 1978, in 1984, then again in 1980, then 1984, the legislature showed that when it wants to preempt MIRA, it does so. And they did so in 1980 under 115A.30, and they did again in 1984 under 41A.04 subdivision 3. The more difficult question, I believe, is the same question. The same question is it too speculative? And I would submit to the court that before Mendota Golf, the city's right, it was too speculative. Because before Mendota Golf, plans were simply guidance. That's how all those practitioners in the land use area, that's how we interpret it. After Mendota Golf in 2006, the plan has supremacy. It controls. It has primary controls. But that doesn't mean we are not asserting here that every plan is subject to MIRA, because that's just not true. The only plans that we say are subject to MIRA are a plan that provides for a use as a matter of right, a permitted use, and where we satisfy the prima facie showing. So 2 parts. So for anyone who has a concern about slippery slope and open the doors and the burden on the cities is we have 2 very, very significant factors that must be satisfied, both of which are satisfied in this case. We know that, despite the fact that the city has repeatedly said that,
This is Justice Hudson. And can you repeat for me again? And what are those two bases?
Yes, Your Honor, I'm sorry. The first one is the plan needs to, like here, actually provide for and approve of particular uses. In this case, it's residential development is approved as a matter of right, or what Chanhassen case calls a permitted use, which means that you can't change it down the road. There's no discretionary approval down the road that's needed. So long as you satisfy the criteria, you get to have your residential development in those zoning districts. The second requirement...
And counsel, what would be an example of the opposite of that?
Would be well, my recollection is you were a city attorney at one point. So you basically have permitted uses, and then you have conditionally permitted uses, CUPs or special use permits. And most of this plan is in the category of special use permits and conditional plans. We're not seeking review under MIRA for that. We are seeking review under the approved, permitted, as a matter of right uses, which is the residential development that no one can stop no matter what. I mean, today, if you put a building permit together next to Justice Thiesen's house for a triplex, you get it. Doesn't matter what the neighbors may say, you get it. The second requirement is that you need to satisfy what Justice Moore was asking about, the prima facie showing. And in this case, we've satisfied it. We didn't just, in part because the plan is massive. So for my protection, I hired an expert, and the petitioners did, who's an environmental expert, who went through the entire plan and produced a 37-page single-spaced report explaining that these are permitted uses, they can be built as a matter of right, and the impacts would be incredible. And those impacts are consistent with what you'd expect when the first line from the state's environmental policy under 116D02 is this line about recognizing the profound impact of urbanization, because you can't avoid it. It doesn't matter how careful the developers are when you cram in hundreds of thousands of people more, or tens of thousands or thousands, you're going to have environmental impacts. Those are the two parts, Justice Hudson. And in this case, if you look at the plan, the best example of these are permitted uses is at page 67 of the plan, where it says, quote, individual lots are permitted to up to 3 dwelling units, end of quotation. There is nothing anyone can do to stop that. The same is true in the other, I think it's 5 other zoning districts. All of them are allowed. The only thing, there are some restrictions on the height of the buildings. And for those who, like me, have to see pictures, the expert report, I thought, did an excellent job of showing that when you allow a triplex or you allow these expansions, what you're doing is you're allowing a footprint. You're increasing the impermeable surface area, which necessarily then leads to greater runoff because there's less surface area, grass, dirt for the water to go to, which creates all sorts of infrastructure issues. The last point
Mr. Perry, Mr. Perry, if I could interrupt you,
yeah.
With regard to your experts report that you just referenced, is your expert assuming full build out of that comprehensive plan? Is that one of the assumptions that's behind your position here?
Yeah, and Justice Moore, the answer is yes. Do you want me to explain why?
Yes, please. Well, right, and you could do that briefly, but I guess I'm concerned about how often comprehensive plans get changed and whether there's any certainty about, the prospect of that full build out actually occurring.
Yeah. First of all, to answer your last point before I get to the explanation of it is that the significance here is these are decennial plans as required by the MLUPA, which means that they're not changing for 10 years. I mean, they can, but I don't know of a city that's changed it midstream. So it's a 10-year plan. So this is not, I don't think the court can assume there's going to be a change. The reason why, and it's on addendum page 35, note 1, Dexter explains why she did this. And the reason she did it is that you have to. If I'm building a landfill, and as Justice Tisa knows, I've jammed in most of the state's landfills, is you can't look at, well, I'm only going to do this, we're only going to expand for, because landfills are permitted for the next 40 years typically. You don't look at part of the landfill, you look at the whole thing. And in this case, the EQB rules actually make it really, really easy, because the two rules on residential development actually say, and this is 4300 subpart 19 and 4400 subpart 14, they require the consultant to review everything that, quote, may ultimately be developed, end of quote. And consistent with that, it's not just our expert who tried to make the worst case scenario. That's what the city of Moorhead did with their 3 voluntary AUARs for their 2040 growth area plan. That's what the city of Saville does. I don't know of a single environmental analysis that doesn't do it, because how do you get to pick and choose what is actually going to happen? My time's up.
Yes, thank you, Counsel. You have 5 minutes for rebuttal. Mr. Ludmer.
Thank you, Chief Justice Gilday, and may it please the court. My name is Yvonne Ludmer, and I represent the city of Minneapolis. The question before the court is straightforward. Should it continue to give Minnesota's environmental protection laws the meaning ascribed to them for decades by Minnesota's legislature, by its courts, by its executive agencies, and all the way down to legal practitioners? And the city's answer here is yes. Appellant's position, on the other hand, is that the court should order additional review beyond that specifically prescribed in the Metropolitan Land Planning Act for comprehensive plans. This would allow potential years-long litigation around every metropolitan area, city, and county comprehensive plan. It would thwart the Metropolitan Council's ability to ensure consistency among local government plans, because some plans would not reach finality until years after others. It would override a legislative scheme designed around environmental review near the point of implementation by requiring review of speculative effects from speculative development scenarios that may never take place. This would essentially turn the judiciary into an advisory body on land planning law. It would also ignore an exemption for comprehensive plans specifically put in place to ensure that review takes place close to implementation and not based on speculation. And where would that end? Every 10 years, the Metropolitan Council assigns to cities and counties in the metropolitan area amounts of growth for which they are responsible, and issues a variety of transportation, sewer, and land use development guides that local governments must follow in creating their comprehensive plans. Allowing this challenge to proceed would allow mirror challenges to those plans as well, as they constrain and guide the local government comprehensive plans and have the same indirect effects as those plans. The legislature has already answered the question before this court, whether a comprehensive plan can be likely to cause material adverse effects so as to subject it to review under mirror. When it passed MEPA, it included a lower threshold trigger for review than that. It was potential for significant environmental effects. And when, in line with that statute, the Environmental Quality Board exempted comprehensive plans from environmental review, there was no challenge that that conflicted with MEPA. There was no question raised as to that. It was obvious that high-level planning laws themselves did not have the potential for significant environmental effects, just as it is clear that they are not likely to cause material adverse effects to the environment. An adverse ruling from this court would require courts to speculate and guess what future development might take place before they could conduct environmental review. It would require it to overturn the MEPA exemption for comprehensive plans as conflicting with MEPA, and it would disrupt the carefully crafted system of comprehensive planning and the scheme under the MLPA that governs comprehensive land planning and use. Thank you, and I'm ready for questions, Your Honor.
Thank you, Counsel. Justice Moore.
Thank you, Chief. Mr. Ludmer, with regard to the history of MERA and MEPA and the interplay here, it's my understanding that this court held in the Pure case many years ago that MERA is not found to be superseded absent, quote, express statutory language to that effect, unquote. Assuming that's the guiding precedent that this court should follow, what language in MEPA can you point to that expressly indicates the legislature's intent that it supersede MERA by adopting these administrative regulations?
I would point, Your Honor, to the language in MEPA that requires review when there is the potential for significant environmental effects. That's as the governing standard for when environmental review is required on government projects, on government actions. And I would say that that language cannot be read harmoniously with an understanding of MIRA that materially likely adverse effects include or will result from a comprehensive plan.
The MEPA exemptions that the EQB adopted rules for, there are a number of others other than the comprehensive plan exemption. Is that correct?
The exemptions, yes, Your Honor.
Like 23 or 24 of them, as I understand them?
So there's the part with the exemptions has 26 parts, I believe, but the specific language relating to comprehensive plans is, I think, includes a series of 3 or 4 exemptions itself.
So are you comfortable with the Court of Appeals holding on, I guess, what we're calling the first issue of this case regarding the exemptions? If we affirm the Court of Appeals on that issue, doesn't that by necessity make a new law that would basically enact that all these exemptions under MEPA would be precluded from any future MERA review under any circumstances as a per se rule?
I don't think as a per se rule, Your Honor, because as I've stated, if an exemption, if one of those rules that the EQB has passed conflicts with MEPA itself, then it wouldn't be effective anymore, and so it couldn't bar a MERA action. And here, the appellants have plainly disclaimed any challenge to the rule to the exemption.
So regarding the stage of the case here, as I was talking to Mr. Perry about, we're on an appeal from a Rule 1202 finding, 1202E finding by the district court. If the court remands and sends the case back to the district court, what process would you anticipate occurring before the district court regarding the MERA prima facie case and the city's responsibility?
Well, Your Honor, that informs a lot of the problems that I see here. It would require the district court, the city appellants to come up with how many thousands possible development scenarios that might result over the next 10 and 20 years, and figure out which of those or which several of those would be the development scenario considered to be compared to potential alternatives. And then that, in order to state the in order to raise the defense, I think that the focus would have to remain on the prima facie issue, that there's the causation question, because otherwise I don't see this as justiciable proposal.
But from a process question, hasn't the history of the statute been that those issues definitely do come up to the court, usually in a Rule 56 context or after some type of evidentiary hearing where there's actual facts presented that are evaluated by the district court?
What I would say, Your Honor, I did find one case that affirmed a MERA dismissal on 1202. It was an unpublished case from 1994. But I would say that that's, in fact, one more case than there have been MERA challenges to comprehensive planning laws or general zoning ordinances. Those cases have not come before the court, and those cases are what should be subject to a dismissal on 1202, because there's no set of facts that could be proven showing that there would be direct understandable effects from those laws that could be analyzed. I would also, I guess I would also like to point out that that according to appellant's counsel, they have already put all their evidence in place as part of their verified complaint. And to the extent that that comprises their evidence, that puts this proceeding here on a similar, footing to Rule 56, and that we have what they claim is their prima facie claim, and we can look at that and see it's based completely on assumption and speculation, and know that that means they can't show causation here.
Well, shouldn't the city be obligated under MERA to provide its rebuttal case to the district court and allow the district court to assess that and determine whether or not the MERA balancing test had been met by the city, or that the city provided an affirmative defense?
I would say no, Your Honor, because I think that's required. I think to get to that point, a prima facie case is required. The city would have the option before the district court of proceeding to Rule 56 solely on the argument that no prima facie claim had been presented here. And that is the argument before the court now, with what appears to be the totality of appellant's evidence.
That's all I have, Chief. Thank you.
Justice Thiessen, do you have any questions?
Just a quick follow-up to one of Justice Moore's questions. I didn't actually understand your answer to why the other exemptions in 4410.4600 wouldn't also be, I mean, if your rule of law is adopted, why those exemptions wouldn't preclude, as a matter of law, mirror review?
And my answer, Your Honor, thank you, is that they would preclude mirror review to the extent that they are consistent with MIPA, with the law of MIPA. So because the exemption for comprehensive plans is consistent with the law of MIPA, that it under that rule.
What does it mean to be consistent with the law? Aren't these rules adopted under MIPA?
They are, but they can't conflict with the actual MIPA statutes. And the MIPA statutes.
So you think some of these exemptions actually conflict with MIPA statutes?
I haven't analyzed the other statutes, Your Honor. But
so to the extent that they don't conflict with MIPA statutes, then MIRA would not apply to marinas, to anything regarding agriculture and forestry, to animal feedlots. Maybe it wouldn't there anyway, but airport projects, mining, paper pulp projects, that wouldn't, to the extent they're consistent, those exemptions are consistent with MIPA, there'd be no mirror review of any of those things.
Thank you for offering me the opportunity to clarify, actually, because I do believe many of those exemptions are specifically exempt in the statutory language of MIPA as well.
MIRA as well. Okay.
Of MIPA. So that those rules include exemptions that are also exemptions in MIPA's statutory language. And when you have those exempted from MIPA, it would not, you're not looking at the same question. You're not looking at whether there's the potential for significant environmental effects. Here, the question with this exemption is there a potential for significant environmental effects from a comprehensive plan? And that has been answered no. With those other ones, you wouldn't have to get there with the statutory exempt with the MIPA statute.
Because they just don't apply at all under the statute.
Yeah. Yes, Your Honor.
So the authority for the EQB to adopt subpart 26 is not a specific exemption, but because it has to do with a potential for significant environmental harm, whatever the language is. I'm sorry, I don't have that off the top of my tongue, but is that's the distinction?
Yes, Your Honor, that the exemptions in subpart 26 have to be consistent with MIPA, and that's the language they would have to meet to be consistent.
Okay, thank you.
Thank you, Your Honor.
Let's see. Justice McKeag, do you have any questions?
Not at this time. Thank you, Chief.
Justice Chudich?
Yeah. Doesn't Smart Growth have a point when it says that this is the only time that it will be able to challenge the entire plan, because once it's in effect, then the challenges will just be on a project by project basis?
I would say they are not correct, Your Honor. Under MIPA, an EAW for a project must identify cumulative potential effects on environmental impacts. The rule I'm quoting there is the rule 4410.1200E. And these cumulative and potential impacts must be considered when deciding whether a project will require an EIS. And those cumulative potential effects are defined in MIPA to require consideration of whether future development is indicated by adopted comprehensive plans or zoning or other ordinances. So I think that the effects of the comprehensive plan are specifically directed to be considered when looking at future projects that are under consideration.
And I'm sorry, I missed your quote. What was the cite to that?
So it's in our brief, Your Honor, and I can get the page cite as well, but it's
That's okay.
The Minnesota Rule 4410.1200E, 4410.1700, subpart 7B, and then the definition of cumulative potential effects is in Rule 4410.0200, subpart 11A.
And I wanted to ask again, I'm sorry if I missed it, but what was your response to, for example, in the Waste Management Act, it specifically said that MIRA doesn't apply. We don't have that here, and MIPA was a later enacted statute.
Yes, Your Honor, and I think the answer is that MIPA specifically addresses environmental review for government projects and put in place this different and frankly lower standard for review than MIRA by requiring review when there's potential for significant environmental effects. And so if comprehensive plans are correctly exempt from that, you can't reconcile those two standards if you allow a review of a comprehensive plan under MIRA.
Nothing further.
Thank you, Your Honor.
Justice Hudson, do you have any questions?
I do, Chief, just a couple. Counsel, it seems to me Mr. Perry and Smart Growth make a strong argument that MIRA is not limited to looking simply at projects, but rather they cite the language from the statute that talks about analyzing any conduct that is likely to materially adversely affect the environment. And then they go on to sort of extrapolate into the discussion Mr. Perry and I had that when you're looking at activities that are clearly permitted by virtue of this plan, as opposed to putting on my old city attorney hat, as opposed to cups and things like that. It does seem to make the analysis a little more targeted, which is what I think they need to do in order to meet their prima facie case. What's your best answer to that?
Thank you, Your Honor. And I would say it doesn't make the analysis more targeted because there's still not a development scenario that has been presented that could reasonably be reviewed. The idea that these are done as a matter of right, I think that's a red herring, because any project still needs review through the city of Minneapolis, and the city of Minneapolis will still need to change its zoning ordinances to come into to accord with the comprehensive plan. The city will need to issue permits for any building that takes place. It's not that any triplex gets approved. If someone came to the city and asked to build a triplex made out of purely asbestos and lead, that would not be approved, and that would clearly have a different environmental effect than a triplex made from other materials. We don't know where those triplexes are going to be built. We don't know what they're going to be built out of. There's no basis for assuming a full build out when, frankly, there's not been a full build out of the city to the extent possible as under current law. And I think that the speculation that is required to proceed with this lawsuit is what prevents them from meeting the causation standard. It's not the conduct. The city is not here disputing, as was in White Bear, whether city action constitutes conduct. It's whether this conduct is likely to cause, and that word cause is important, materially adverse effects to the environment. And that's already been answered by the EQB and by the legislature, and the answer is no.
Counsel, though, I guess the other concern that I have, though, is, when you look back at our cases, especially since Walsh, in terms of our Rule 12 cases, we've been we've read Rule 12 pretty liberally in terms of what it is that a petitioner or plaintiff needs to show. And that bar is relatively low, and I think for good reason. And so I guess I'm just wondering whether or not, well, it seems to me we would have to say something a little different than what we've been saying about what it takes to survive a Rule 12 motion. And I'm uncomfortable about that, so I'm looking for a good reason to do that.
Thank you, Your Honor. And as a defense attorney who practices in federal courts as well, I'm definitely familiar with the different standard here. And I would say that it is met here because they would have to, that there's no set of facts that they could show under which a comprehensive plan itself could cause direct effects to the environment.
But counsel, what do we do? I mean, I look at this report from the Sunday environmental analysis, and it's pretty thorough. I mean, it acknowledges that we don't know exactly what will be built, but based upon the plan, they do a fairly thorough analysis, and likewise in the verified complaint. I don't know. It just seems like it meets that low bar.
Your Honor, I would point to the language that was raised previously about the assumption of immediate and full build-out. And Mr. Perry's response was that that's mandated. And frankly, it's not. There's no, the mandate in MIPA for when you assume immediate and full build-out is contiguous development of land by the same developer. This is not contiguous development, and it's not the same developer. The city of Minneapolis doesn't own this land, as that's one of the requirements for that as well. It's the report is based on speculation, and further, the report even acknowledges it is not, part of the assumptions that they're making are that the city's transportation plan will not be updated in the next 10 years. That an update to the transportation plan is specifically contemplated in the 2040 plan. It assumes A, that nothing else will change before there's a build out, and B, that there's going to be an immediate full build out tomorrow. And I don't think that I think that, this court would look just as skeptically on any complaint coming in and saying, I assume my neighbor will do something in the next 20 years. And based on that, I speculate that it will cause me these injuries. And therefore, I should be able to state this claim now. I think that this court would look just as, would have a similar jaundiced eye to the one that we're requesting here. And also, Your Honor, to your previous question, I want to make one point as well. Mr. Perry, repeatedly spoke of as a matter of right and referenced the Mendota Golf case, saying that once a comprehensive plan is passed, everything has to be in line with that. The result of that case was that the action was sent back to the city to either amend its comprehensive plan. It found a conflict between a comprehensive plan and zoning ordinance, and it was sent back to the city to either change its comprehensive plan or change its zoning ordinance. The court didn't say the comprehensive plan controls, go do this. So that again speaks to the, in my opinion, lack of wisdom in conducting an environmental review here based on speculation of what might happen in the future.
One final question, if I may, Chief, kind of related to that. When Mr. Perry said that the city is not likely to change its 10-year plan, I don't know, maybe I misread your facial expression, but I thought I saw something there. Did I? And if so, tell me what it was.
Yes, Your Honor. There's a nonprofit organization that I'm involved with, and the first amendment to the comprehensive plan was passed a couple months ago relating to a building proposed by that nonprofit organization. This plan was amended and it's going to be amended. It's not, there's going to be further changes, and I understand that that's not part of the record, but I'm attempting to explain what face I might have made, Your Honor.
Justice Anderson, do you have any questions?
Counsel, do you agree that the comprehensive plan, or that the zoning ordinances must be in compliance with the comprehensive plan?
Yeah, I would say that when the city wants to change its zoning ordinances, if it wants to change them into something that doesn't meet the comprehensive plan, it would have to amend the comprehensive plan at that time.
And that's the current state of the law as far as you're concerned?
Yes, Your Honor.
If that's true, I don't understand the argument as to why the comprehensive plan is not subject to litigation. The world in which I'd prefer to live in, we'd go back to comprehensive plans as advisory documents, but they're not advisory documents anymore. Somehow I wasn't consulted on this. I don't understand how that happened. But the fact of the matter is that, the zoning ordinances have to be in compliance. And why isn't that? I understand there's this argument about the exemption under the statute. That's a separate issue. But it strikes me, the property owners have the right to litigate these questions. Why not?
Well, Your Honor, what I would say is it comes back to the speculation issue again. And this reaches Justice Hudson's question previously. Part of the city's efforts here are equity. They want to achieve an equitable result across the city, where previously certain types of multifamily homes were only allowed in certain redlined areas. The city said, no, we want to have these be allowed anywhere in the city. That doesn't necessarily mean there will be more development than there otherwise would have been. That just means that this development can take place in different parts of the city. And until we know where that development is taking place and what form it's going to take place in, we don't know, there won't be enough information to say that there's a causation, there's likely cause of material adverse effects to the environment.
Well, here's my problem with that argument, and I don't disagree with you on the merits. And I have fairly retrograde views on the whole subject of zoning anyway. We could have a discussion about whether Village of Euclid was properly decided. But setting all of that aside, what we have here is, it seems to me, the argument that Mr. Perry made, that by the time you get around to discussing the overall effect of the comprehensive plan, the response from the city is going to be, well, we've already given, building permits and have already acted in accord with the zoning ordinance with the following small little developments here, there, and everywhere. And there's ultimately no opportunity for discussion about whether or not the comprehensive plan itself impairs the rights of those individual property owners. I get it, why it's a problem for the city. I think this whole area needs some attention. But on a Rule 12 motion, I'm wondering why we don't allow the process to go forward.
Well, I just have two responses to that, Your Honor. First, I would refer back to the MIPA rules that I mentioned earlier, where comprehensive plan effects are considered as development continues. And if 99 triplexes don't create a problem and the 100th does, given the comprehensive plan, that is considered. And I would say also that that's a question for the legislature, not this court. The scheme for the legislature when it passed MIRA was to say to individuals, you don't need to show economic injury for environmental effects anymore. You don't need to show personal injury to environmental effects anymore. What you need to show is environmental effects. And here, we're not talking about an actual development. We're not talking about an actual building. We're talking about speculation of what might end up happening. Yes, some 150,000 new units may be built, but will they be? No, not within the next 10 years, unless the Metropolitan Council massively mispredicted the growth that would be in the city. What maybe in 10 years or maybe in 3 years, the economic situation from the current pandemic or otherwise has changed things to the point that some of these rules don't make sense anymore, and the city will be changing them. And then every time we change them, we come back to the courts for 2 or 3 years of litigation under MIRA. That's not what the legislature planned. That's not the scheme the legislature created under MIRA and under MIPA. It required looking at on the ground, tangible, what is happening here and what effects can we expect from it.
Thanks for your response, Counsel. I don't have anything further, Chief.
Thank you, Counsel. Your time has expired. Mr. Perry, you have 5 minutes for rebuttal.
I have precisely 5 comments, so hopefully I can get them in 5 minutes. The first one is I wanted to go back to the Chanhassen case. I referred to it, but I think it's important when we look at the plan, because Chanhassen says that when a city has designated a specific use as permissible in a particular zone or district, the city has exercised its discretion. End of quote. That's what we have here. They have exercised their discretion with the plan. They have approved of this massive residential build out for good or bad reason. Second point is that Mr. Ludmer's initial arguments about why you shouldn't apply MIRA to this case are arguments for why the legislature should amend MIPA or the MLUPA to preempt those statutes from MIRA in this context. They're not legal arguments as to why our claim fails. Third point is Justice Moore and Justice Thiessen hit upon what I think is maybe the most important aspect of this entire case, is that there are 25 exemptions. And of the 25, only one of those exemptions, and this is under 4410, 4600 subparts 1 through 27, there's 25 exemptions. City said, represented the court that, well, a number of those are actually statutorily prescribed. There is exactly one of those that is statutorily prescribed under 116D04, subdivision 2AF, feedlots are prescribed, which is why Justice Thiessen, I believe, when he went through some list of some of those, he disqualified feedlots because that is statutorily prescribed. The rest of them are all agency created. And the agency under the line of cases about agency law, agencies cannot pass rules that trump statutes, period. And the holding from the Court of Appeals would, even though they don't mention the other 24, would exempt all 24 other ones without any statutory protection except for feedlots. And Justice Thiessen went through a few of those, but they run the gamut. It's feedlots, it is solid waste, it's mining, it's industrial, it is the gambit of things. And I don't think it's possible to have a consensus to say those should all be exempt from MIRA. And there's certainly no statutory authorization for it. The fourth point is Justice Hudson asked a question along the lines of what's the difference between MIRA's reference to any conduct versus what MIPA provides. And I would refer Justice Hudson, to that question is the card case, and I think it's in a footnote, but they explain that both statutes have this broad perspective. MIRA is any conduct, and MEPA, I don't think it's any conduct, but something broad like that. But then the rules, not the statute, is where it became narrowed to a project. And the card case explains that, ironically, up until the very last version of the draft rules, it referred generally to any conduct. But in the last version of the rules, they limited the MEPA environmental reviews to projects. Again, right, wrong, or indifferent, it was changed by rule, not by statute, and it is different than what is in MIRA. Two different worlds. The last comment is with regard to the prima facie showing is under the incredibly broad scope of MIRA, which says that the paramount importance of all these statutes, MEPA, PPSA, MIRA, is the protection of the environment. Well, if that is the goal, the protection of the environment, and we are to do it before there is an impact, then this is a casebook example of how you anticipate the environmental harm to come that has been prescribed by the plan.
Can I just ask a question here, Chief? I'm sorry,
Yes.
I
Yes, go
waited
ahead.
way too long, but where does this end up? So you prove your prima facie case, they don't have an affirmative defense. What is the equitable relief here?
The equitable relief, well, as this court said, and I think it's in a footnote in the White Bear Lake case just a few weeks ago, was the district court has broad equitable relief. By statute, Justice Thiessen, I think it's more focused on injunction is that the city can't go forward unless they can satisfy their prima facie showing under 116B04B. As a practical matter, where I hope this goes is we prove our case, they can't rebut it because I don't think there's a chance in this world of them rebutting it, Justice Thiessen. And then we address some of these deficiencies, which Justice Hudson correctly pointed out, that are really at the core driving this. And I think that's why you have lawsuits, is to bring people together, at least from my perspective, to advance what's really at issue.
Okay, thanks.
All right. Thank you, counsel. Your time has expired. Thanks to both counsel for the help you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course.